Now, Justice Thomas wasn't the only one who wanted the court to do more. Justice Jackson wrote her own concurrence. The court holds that Mexico's complaint fails to plausibly allege that gun manufacturers aided or abetted violations of firearm laws as necessary to trigger the predicate exception to the Protection of Lawful Commerce in Arms Act. I agree. I write separately to explain that, in my view, the complaint's core flaw is its failure to allege any non-conclusory statutory violations in the first place. Interesting. Now, Justice Jackson makes a point. Not only did Mexico not argue a plausible instance of aiding and abetting, they didn't even show an actual legal violation in the first place. Tellingly, that failure exposes Mexico's lawsuit as precisely what Congress passed PLCAA to prevent. PLCAA was Congress's response to a flood of civil lawsuits that sought to hold firearm industry responsible for downstream lawbreaking by third parties. Activists had deployed litigation in an effort to compel firearms manufacturers and associated entities to adopt safety measures and practices that exceeded what state or federal statute required. Congress expressed concern that these lawsuits attempted to use the judicial branch to circumvent the legislative branch. The PLCAA embodies Congress's express rejection of such efforts, stymieing those who, as Congress put it, sought to accomplish through litigation that which they had not been able to achieve by legislation. Put differently, PLCAA reflects Congress's view that the democratic process, not litigation, should set the terms of gun control. While I frequently disagree with Justice Jackson, she has a very valid point here. This case is exactly what the PLCAA was designed to prevent, including protecting manufacturers from retaliatory litigation for their participation in legal commerce. It is for these reasons that I view Mexico's allegations as insufficient to satisfy PLCAA's predicate exception, regardless of whether the business practices described might suffice to establish aiding and abetting or other forms of vicarious liability in distinct statutory common law contexts. Devoid of a non-conclusory allegation about particular statutory violations, Mexico's lawsuit seeks to turn the courts into common law regulators. But Congress passed the PLCAA to preserve the primacy of the political branches, both state and federal, in deciding which duties to impose on the firearms industry. Construing PLCAA's predicate exemption to authorize lawsuits like the one Mexico filed here would distort that basic design. You mean when Congress passed legislation to stop courts from acting as regulators of the firearm industry, they actually meant to prevent the courts from acting as regulators? It is with all the sarcasm I can muster that I say, inconceivable.